Hi, I'm attorney Chris Brown with the Bond Law Firm. Today I'm going to be discussing with you the essential estate planning documents that you need to have in place after your passing to make sure that your wishes are carried out and that the burden upon your family members is eased. Recently, there was an AARP study done that showed that 60% of all Americans don't have a will or trust-based planning in place. That means that only 4 out of 10 people have the documents that they need. And as you move into the baby boomer generation and beyond, those percentages do increase. But what that means is that a huge percentage of the American population, younger than the baby boomer generation, doesn't have any planning in place. And that's scary because anyone with a family, especially if it's a second marriage or special needs children or really any special circumstances, or if there are even modest assets involved, there needs to be an estate plan in place. Now, the two most common types of estate plans are will-based planning and trust-based planning. And we'll talk about both. But first, let's talk about will-based planning because that is most common. Now, the purpose of a will is to direct your assets after your passing and also to determine who you want to be guardian of your underage children. And that's incredibly important stuff. Now, the only drawback of will-based planning is that it means that you're going to go through the probate process. And what the probate process is where your will gets handed to the judge and the judge goes over it and ensures that it is the correct and valid will that represents your estate. And what they'll do is provide your executor with something called letters testamentary. And those letters testamentary are the evidence that your executor has the authority to carry out the administration of your estate. And with those letters, they'll go to the banks, the financial institutions, and be able to close out your accounts and distribute the assets. The problem is this does involve the courts, absolutely. It means your information becomes public information. And it's also a time-consuming process. Even though here in Texas, there's a more efficient and cost-effective probate process, it still takes at least 8 to 10 weeks. Now, the other type of planning, oh, one more thing. A will does not kick in until after you pass. And that's important because it means that it is not an instrument to plan for your disability. So, now let's talk about trust-based planning. Trust-based planning is a complete and comprehensive replacement for will-based planning. It gives you more control of how your assets are distributed, and it can also provide additional protections. And the method that we prefer or recommend is the revocable living trust. And that way, what it does is it provides you disability planning during your life, but then after you pass, it can also provide asset protection from divorce and lawsuit type predators, sorry, one and the same sometimes. So with your will or trust-based planning, you've built a foundation for your estate plan. And now we're going to build upon it with additional ancillary documents. And the first of which we'll discuss is your medical or healthcare powers of attorney. And the purpose for this document is for you to direct an agent who will be able to make course of treatment decisions for you if you're unable to make them yourself. This is differentiated from a pull-the-plug document in which you're actually making decisions in advance for yourself. This is a separate document who says who can make all other course of treatment decisions for you if you're unable to. Now, one thing we see a lot in our office is medical powers of attorney documents that don't have the proper HIPAA language. And what that means is that there can be doctors out there, and when you hand them the healthcare power of attorney, they receive it, and although you have the power to make the decision, the doctor doesn't know whether they're going to get sued or not for giving you the information to make that decision. So we make sure to include HIPAA documents in all of our medical powers of attorney, and we also provide a standalone HIPAA document because we believe it's very important. Another ancillary document that's highly important is your statutory durable powers of attorney, or otherwise known as financial powers of attorney. And the purpose for this document, it's similar to the medical power of attorney. It decides which agent or who you want to direct as an agent to make your financial decisions and handle your assets if you're unable to do that yourself. And this is very important for disability planning. However, I will say that it has limitations, and many of those limitations can be overcome by the use of a revocable living trust. So, up to this point, we've discussed will-based planning, trust-based planning, and the ancillary documents of your statutory durable powers of attorney and medical powers of attorney. Now, these are just a few of the essential estate planning documents. They're essential not only for you, but for your loved ones. Imagine the stress of one of your loved ones passing. It's just unbearable. But then multiply that by 100. And that's what you have when you don't have the proper estate planning in place to help your family members carry out your wishes, and at the very least, remove conflict from your passing. So, what I'd like to do is invite you to one of our free educational seminars, or call and come in for a free consultation. And that way we can discuss your personal situation, because that's just what estate planning is, it's personal. And we can get a feel for what your situation is and develop a plan personalized for you and your family. Thank you for watching, and we look forward to seeing you on the next video. Thank you. Bye-bye.